Hello, I'm Locke Meredith. I'd like to invite you to join me on the next Legal Lines, where we have as our guest Judge Tim Kelley. He's a judge on the 19th Judicial District Court. He's going to talk to us about the status of the construction of the $109 million new courthouse. He's also going to discuss with us how the trial court works versus how the appellate courts work. He's running for the First Circuit Court of Appeals, so join us on the next Legal Lines with Judge Tim Kelley.
Want to learn the secret to big savings on TV, internet, and phone? It's bundling your services with Cox. When you bundle with Cox, you get digital cable, high-speed internet with Power Boost, and telephone, all for one low monthly price. That's 3 fantastic services at one low price that will make you smile. The secret is out. The more you bundle, the more you save. So get a whole lot and save a whole lot when you bundle with Cox.
Welcome to Legal Lines. I'm Locke Meredith, and I'm very pleased to have on the show today Judge Tim Kelley. He's a judge for the 19th Judicial District Court. Judge, thanks again for being on the show.
Locke, great to be here, my friend.
Well, appreciate you coming in. Congratulations is in order. You just have a new child, but tell the folks a little bit about your personal history.
Thank you. That's true. I'll very quickly say Kernan Davis Kelley was born on June 21st, so my wife Angela and I are obviously very thrilled about that. I went to school at undergraduate school at Cornell University, graduated there in engineering. Moved to Baton Rouge in 1976, worked as an engineer for about 4 years until I got licensed, and then I went to law school at LSU at the Law Center there. When I finished there, I went and clerked with Justice Fred Blanche at the
Supreme Court.
At the Louisiana Supreme Court for a year, and then went to work for a large firm called Phelps Dunbar. Became a partner there, worked in the Baton Rouge office for several years, and then in 1993, I left there and started my own general practice firm, very much like what you would do. Did that with another gentleman called David Gary, and we had 3 to 5 associates working with us. In 1996, I had the opportunity to run for district court judge. I was successful in that and have been sitting as a state district court judge since then.
Well, it's about 13 and a half years.
Yeah, almost 14 years now.
Long time.
Time really flies, doesn't it?
It does. That's right. We're not as old as we look.
Yeah, I used to have dark hair. You used to have
hair. I used to have hair. That's right. That's right. Well, let's talk about your experience as a trial court. You've been in the role of Chief Judge for the 19th Judicial District.
That's right.
You have been Vice Chair with Judge Janice Clark being the Chairman, constructing $108 million
108 to $110 million would be the
courthouse.
Final price tag on that thing. Yeah.
So tell the folks basically what you do as a trial judge, because that sounds like a lot of hats.
A state district court judge is exactly what you just said. It is the trial judge. If you have a dispute with another party and you cannot resolve it, you would file a lawsuit and you would go before a judge to resolve it. That judge will either decide it, or it will be decided by a jury presided over by the judge.
And what decides whether or not it's going to be a jury versus a judge, or what they call bench trial for the
Generally, it's the jurisdictional amount is what they call it. You can get a jury trial if the amount of damages will exceed $50,000. If so, you're entitled to ask for a jury.
And either party can ask, either the defendant or the plaintiff can ask.
That's correct. Either party can ask, and I would say generally, usually the defendant ends up asking for a jury trial, because many times the defendant is represented by an insurance company. And insurance companies, being national companies, are always afraid of local courts and whether there be a problem with the judges being closely aligned with the local people. So they ask for a jury instead.
And that kind of changes the way that the evidence is presented to the court.
Absolutely. If you have a bench trial, it's much less expensive to go forward, because there's no time educating a jury involved. The judge has been given briefs ahead of time. We've read them. We've read the depositions of the doctors and the other people, and we know what the case is about. And then you'll present your witnesses. Your client would testify. Your doctors may or may not testify. You may give me the deposition to read. It goes much quicker. It's less expensive for the parties. With a jury trial, they have not read anything ahead of time.
And don't know the law.
And they don't know the law. That's exactly right. I have to instruct them on the law.
So in litigation at the trial court level, that's where trials are held. That's where the evidence is presented either to the judge or to the jury. But before you get to the trial, There's
very complicated procedure.
There's a process by which information is collected and the way legal issues are resolved before you ever get to a trial.
The way our legal system works, and what we're talking about now is a civil trial, not a criminal trial. A criminal trial, the difference being it's the people of the state through the district attorney bring a charge against an individual, the defendant, and it's the people versus that individual. The civil trial that we're talking about now is an individual suing an individual, two citizens that have a dispute. One will file a lawsuit, and the way our system works is it's really an open book system. It's not like you see in the movies. There's nobody that's going to stand up like in Perry Mason and say, all right, you're right, I'm the one that did it, I'm sorry, I killed so-and-so, or I stole the apples. That doesn't happen. By the time you get to trial, everyone knows who the witnesses are and what they're going to say. They know what all the exhibits are and what the exhibits say. And there's still a dispute. The way they find that out is a process called discovery.
And discovery for the folks, like you said, is really the description of the process of collecting information.
Exactly.
And that includes what? Depositions, interrogatories. Explain to the folks kind of the technical components.
You are entitled as a party to find out all the information that the other side has.
It's to eliminate surprise.
Exactly. The whole idea of our system is there is no surprise, because what you want to do is resolve the dispute without having to go to trial. Normally, once everyone has all of the information, 9 times out of 10, there won't be a trial, because once each side realizes what the whole story is, they'll settle the case.
And even though they may not agree necessarily on all the
Exactly.
facts or on all the law, they have a general idea of how it'll go, and if
Right.
you've got reasonable people on both sides, the case is, like you said, I think statistically is 90% of them settle.
Exactly. So the first thing that you do is you send out what's called a request for interrogatories and a request for production of documents. Interrogatories are no more than written questions that require written responses from the other side. Request for documents is self-explanatory. Give me the documents that fit this description.
And photographs, and they can go to the sites, all that kind of stuff.
Exactly, and it would also include not just documents, but objects, such as preserve the car that was hit,
Sure.
Things like that. Once that's done, that will help each party to identify who the witnesses may be in the case, and then they will ask for depositions. Depositions are sworn testimony by a witness.
And it's really just like testifying in court in the sense that whatever you say in a deposition can literally be introduced at trial in certain circumstances.
Absolutely. And there's two types of depositions. There's a discovery deposition where you're just trying to find out what this person knows. And then there's a perpetuation for trial deposition, which is when you believe that that person may be out of state or may not be able to get to the trial.
Or might die before the trial.
Or may be very ill, exactly. And so you want to get their testimony to be played before the jury, and that's generally done on a video deposition.
And in fact, I was going to ask that question. It's not limited to just written.
That's correct.
You got a video camera just like we have here today, looking at the person who's being deposed, who's talking. And
Absolutely.
that way, frankly, the jury or the judge gets to look at things and see how they're acting and their tone of voice, all of that.
Exactly. Now, all of this discovery will generate certain issues between the parties. They will realize that maybe the lawsuit that has been filed has some problems, legal problems with it. The legal theories may not be correct. So what will happen is there'll be a series of motions filed stating whether there is a cause of action or not. That's called an exception. Saying that the law does not provide you a remedy based on these facts. That would be a summary judgment. All of these motions are filed ahead of time, and they're heard by the judge, not the jury. And it's all done through a motion practice, and normally those are heard on Monday mornings. And that will pare down the case to the essentials of what really are the legal issues and what really are the factual issues.
And sometimes those motions, Judge, they can either result in the termination of the case, for example, a motion for summary judgment on liability or something like that, or like you said, they can hone down and whittle away so that when the case finally goes to trial, it's just very limited issues and facts.
That's exactly right. It's a complicated procedure, but it gets us where we need to be.
So once you collect all the information, which is called discovery, then you go ahead and you move into the part of preparing for trial.
Correct. And once you move to the trial, you'll call your witness as well. And if you have a jury, you'll pick the jury.
All right, let's talk about that on the next segment. This is Locke Meredith with Legal Lines, and Judge Tim Kelley. We'll be right back.
Everybody loves On Demand from Cox. Well, did you know the love's about to grow? Soon, your on-demand menu will have a whole new look, making it easier than ever to find your favorite shows, access hundreds of movies, and thousands of free programming choices, even HD. Just like that, so you can watch what you want to watch, when you want to watch it. It just keeps growing better every day. See what's coming on demand and get more out of what you're into with Cox Digital Cable.
Welcome back to Legal Lines. I'm Locke Meredith, and again, very pleased to have on the show today Judge Tim Kelley. He's a judge on the 19th Judicial District Court. Judge, we were talking about your 13 and a half years on the trial level bench and describing the process for the folks. We talked about collection of information. Now let's talk about how the trial takes place.
Well, it's very technical. A lot of people wonder, should I get a lawyer or not? There's a very, very technical and complicated set of rules that dictate how evidence can be presented to the trier of fact, be it a jury or the judge. And that is why we always advise, get a lawyer. We really do think that you need somebody who knows how to get the evidence in, because if you're a layperson trying to tell your story before the court and the other side has an attorney who knows how to stop you technically, we're not allowed as a judge to show any deference or give you any help. Both sides have to be on an even keel. The very first thing that happens is you would select a jury, and that is a procedure called voir dire, or a search for the truth.
And that's what folks always sometimes seem to dread, and that's getting the old letter in the mail that says, come on down, we're going to put you in a jury pool, and explain that process to folks.
What happens is we send out 600 notices, and usually about 150 to 200 people will actually show up. The rest of them we have a little problem with, and we're not going to discuss what we do with them, but it's not a nice process for them.
It's actually an extraordinary opportunity for you to participate in the system and play a vital role. You will be the judge if you're on a jury.
I've had over 200 jury trials that I've presided over. I've talked to every single juror that's actually participated in a trial, and every one of them has told me, you know, I really didn't want to do this. It took up my time, took me away from my family. But now that I've done it, when I raised my hand to take that oath, all of a sudden it became real. I'm deciding
That's right.
the life and future of these people. And they take it very seriously. They thoroughly enjoy the experience. And it's a unique experience. I think everyone should at least one time get to serve. It's such a great thing to do.
And it's truly an honor and a privilege.
Absolutely.
It is absolutely vital to our democratic system.
You know, there's only two things, I always say, and I've told you this before, there's only two things our country asks of us for all the benefits and opportunities we're provided. One, in times of war, we ask our young people to go fight and die for our way of life. And the other thing is jury duty. How tough is jury duty?
Yeah, compared to the other.
Absolutely.
Amen. Well, so let's describe the process of voir dire.
Probably about 36 to 40 people will be called into a courtroom, and by random lot, their names will be shuffled. They'll be on cards, and by random lot called up about 12 or 13 of them at one time to be asked questions. The judge will ask preliminary questions, and then each attorney will have an opportunity to ask questions. And then the judge and the attorneys have an opportunity to eliminate those that they believe would not be proper for this particular type of case. For instance.
And that's called a challenge.
That is a challenge, correct. For instance, someone who would not be appropriate for an automobile accident where someone died is someone whose daughter, sister, brother, loved one had been killed in an automobile accident recently.
Because they would understandably potentially be biased.
Well, they would be very emotionally biased. They'd be difficult not to be. And really what we're looking for in jurors is the same thing that any potential juror would want to have if they were one of the litigants. Someone who doesn't have a dog in the hunt.
It's kind of like the golden rule. Do unto others as you would have them do unto you.
Absolutely. You want someone who doesn't care who wins. They want to know what the issues are, what the facts are, so they can make an honest decision. And I would say all of our jurors tend to do that. We're really. And
so the purpose of those questions that first the judge asks the group that is called up and then the lawyers is to identify those areas where it potentially disqualifies that potential juror. Once that process is completed, you then have your jurors and then you have some alternates. For what purpose?
Well, depending on how long the trial goes, and our jury trials generally last anywhere from 4 days up to about 3 or 4 weeks. For the longer trials, a juror could get sick. a juror could die or get in an accident. There could be something that happens where a juror's child is ill and they cannot continue to serve because they have to care for their child. So you have to have somebody there who's not one of the 12 jurors who is listening to all the evidence.
They don't even know they're not a juror.
That's exactly right. We don't tell the people who are the alternates that they're alternates as far as the people sitting up there, and we always pick more than 12 people. We either have 13 or 14 people up there. And the alternates don't know that they're alternates. And once the trial is over, before they go back to decide the case, I'll release the alternates, and they won't be allowed to go talk about the case. It's a great process. Each attorney then will give an opening statement talking about what their case is about. It's kind of a roadmap. This is what you're going to hear. This is where they start to teach the jury what the case is about. And then the plaintiff will have an opportunity to present his case.
And typically that's done by what, Judge?
Well, they'll call witnesses up to the witness stand to testify, to identify documents, to get pieces of evidence into the record legally. And that's why it's very critical that you have someone who knows what they're doing to help you get it in, because the rules of getting those pieces of evidence into the record are very complicated.
And so the purpose of the trial is to present the information that's been accumulated prior to the trial via discovery to that jury. Give them all the information, and to the extent it needs to be explained, they have experts testify about that information.
That's exactly right.
And then what happens?
Well, then what happens is after all the evidence has been presented, each of the attorneys will have an opportunity to do what's called a closing argument, where they have an opportunity to ask the jury to find in their favor, to basically say, this is what the evidence is, this is what we believe it says, and this is what we hope that you will do with it. Now, because the plaintiff has the burden of proof, the plaintiff is the one bringing the claim, they'll get to do a closing statement, the defense will do a closing statement, and then the plaintiff will have an opportunity to make some final statements. After that's done, the judge will then instruct the jurors on the law.
Judge, what's really interesting too with the new building that you've been working on, it's high tech, and it actually facilitates educating the jury in an effective way because we have all these high-tech instruments available now.
Yeah, you see a smile come on my face because for the last 11 years, Judge Clark and I have been working to get this thing done. At the courtrooms, the attorneys will be able to plug their computers into their counsel tables and into the podium where they speak from and bring up their PowerPoint presentations, bring up the evidence. Rather than having a piece of paper passed around to each jury, it's going to be on a huge screen for them all to see.
Excellent.
It's going to make it much quicker. You'll be able to put your videos up on the large screen for them. They won't have to read things. It's really going to be very high tech.
All right, so you indicated that after the evidence is presented and both sides give their closing arguments, then the judge basically tries to educate that jury on the law. How does he do that?
Well, it takes about half an hour to read what's called jury instructions, and the parties ahead of time ask for certain instructions to be given. The judge may or may not include those, but at the end of the trial, the judge will teach the jury what the law is by reading the instructions.
All right, we'll continue this on the last segment. This is Locke Meredith with Legal Lines and Judge Tim Kelley. We'll be right back.
Did you know that high-def programming from Cox is free? That's right. Cox gives you a ton of HD channels for no additional cost. Your favorite HD channels, your local channels in HD, and even more HD choices with On Demand, and more being added every day. So get a whole lot more HD for a whole lot less with Cox Digital Cable.
Welcome back to Legal Lines. I'm Locke Meredith, and again, I'm pleased to have on the show today Judge Tim Kelley. He's a judge on the 19th Judicial District Court. We've been talking about having a trial, Judge, and you've handled, what, over 550 of them?
Exactly.
Civil and criminal.
That's correct.
So the information has been provided to the jury, we said. The judge has educated them on what the law provides, and then they go back and they do what?
They go back and they deliberate. They go over the evidence, they make a decision, and in a civil case, 9 out of 12 have to agree in order to render a verdict. When they've come to a decision, they will fill out what's called a jury interrogatory. It'll be 1 or 2 pages long, and it'll ask certain questions that they'll have to decide. Was somebody at fault? Was their fault the cause of the damages? If there were damages, what type of damages and how much should be paid.
And if there are multiple defendants, they'll have to chop up the fault between all those defendants.
Exactly, and they'll allocate fault.
And the reason that the jury verdict form or questionnaire interrogatory is used is to help on appeals if that's necessary, is it right?
Absolutely. Now, if once they come back with their verdict, the verdict is not the answer to all of the questions. The verdict is one side wins or the other side wins. If the plaintiff wins, how much money does he get?
That's right.
So once that's done, if a party is dissatisfied with the result, they have a right to go to another court, the appellate court, and ask them to review that trial and that process from the filing of the lawsuit all the way through the end of trial to see if anything was done wrong, to make sure all of their rights were preserved and it was done correctly. That is called an appeal. And that's what the appellate court does. They will review it. At that stage, there will be a hearing at the appellate court level where your attorney will go, and the people don't testify at this
right,
point.
no trial.
There is no trial. The attorney will write a brief expressing what his position on the issues are, and the two attorneys, or three or four, however many are involved in it, parties are involved, will go up and argue before a three-judge panel. That panel will then have a designated judge who is supposed to write the opinion. He will write an opinion. He will then circulate it to the other judges. If they agree, they will sign it, and it'll go out as the decision. They'll either affirm, which means we agree with what happened, there were no problems, or they will reverse. If they reverse, they have two options. They can reverse and remand, which means they send it back down to the trial court to redo it, or they can reverse and render, which means there's no reason to go back to the trial court. Here's the mistake that was made. It was an obvious mistake. We're going to give the decision ourselves, and then they will render a decision.
And Judge, there's actually delays after the trial within which you have to file that appeal to the appellate court, and if you don't do it within those time delays, you lose that right to appeal the decision.
That's right. You first have 10 days to ask for a new trial. A new trial is almost never granted.
And that's basically asking the judge, hey, I want to do this all over again.
That's exactly right. Once that time period is over, you have 30 days to file what's called a suspensive appeal. That is where you're going to have to file a bond that's equal to 1.25 times the judgment value to stop the enforcement of that judgment.
So for example, if a judgment at the trial court level awards $100,000 to the plaintiff, if a suspensive appeal is filed, that defendant will not have to pay to that plaintiff $100,000 during the appeal process.
That's correct. They'll file what's called a bond. And the reason for the bond is since they don't have to pay now, if they are not successful on their appeal, there will be a payment on the judgment.
It's like an insurance policy.
That's exactly what it is. And you get that insurance policy so that the person who won the case cannot collect against you until the appeal is over.
Now there's another kind of appeal.
There is. You can also do what's called a devolutive appeal. We have fancy names as lawyers, and I think we probably do it so people have to
confused,
wonder what's going on. But a devolutive appeal is the same as a suspensive appeal, except that during that pendency of that appeal, the person who won can collect on the judgment.
So in our example, that $100,000 would have to be paid by the plaintiff.
That's exactly
by the defendant
by
to
the
the plaintiff.
To the plaintiff, they would have to pay, and then if they won on appeal, they would get the money back, plus the interest that accrued while the plaintiff held that money.
All right, so say a judgment's rendered for $100,000, the defendants appeal it. They have certain deadlines within which they have to file a motion with the trial court, putting them on notice that an appeal is going to be taken, and the trial court does that. They file their appeal, and the appeal takes how long?
Well, it depends on what circuit you're in and how busy the circuit is. We are in the First Circuit Court of Appeals. The First Circuit is a very, very busy circuit. They handle all of the matters for a 16-parish region that basically is central Louisiana and south central Louisiana that goes all the way from the Gulf up to the Mississippi border. And it has the capital in it also, which means every state lawsuit, every suit against the state has to go through East Baton Rouge Parish, which goes to the First Circuit. So their backup, it can run anywhere from the time you file your appeal until you have a hearing, could be up to a year, sometimes a year and a half before you can get a hearing. Once there's a hearing, there is a 6-week turnover, during which time, after the hearing, within 6 weeks, you should hear, unless the author of the designated writer of the opinion doesn't get the agreement of the other judges. Then it will be transferred to another judge to write the majority opinion for.
I see.
And so you'll be a 6, 12, 18-week period before you'll get your decision.
Explain to the folks how a appellate court judge's roles differ from that of a trial court, because you've been a trial court judge and you're now running for the First Circuit Court of Appeal. Explain to the folks how that differs.
Well, the way it differs is basically, if you think of it as students and teachers, the students are the trial court judges who make decisions and basically are taking exams the whole time in all the decisions they make, and the appellate court is the teacher who grades the papers. They review what was done, determine whether it was properly done. If it wasn't properly done, they write an opinion explaining how to properly do it and send it back down. The appellate court is very, very important to protect people's rights in case there's been mistakes made during the trial court that have impinged upon their rights.
And my recall is there's 42 district courts, there's 5 appellate courts, and 1 Supreme Court, Louisiana Supreme Court.
That's exactly right.
Explain to the folks how the Louisiana Supreme Court's decisions affect the appellate courts.
Well, one has to understand the way the structure works is there's a basic level where your trials are done. That's the district court. And that's what I am as a district court judge. If you're dissatisfied with that result, you would file an appeal to the appellate court, to the First Circuit Court of Appeals, or 1st through 5th.
And you have an absolute right to do that.
You have an absolute right. No one can deny you that right to do it. You must do it within the time periods allocated, but you have a right to do it. If you are dissatisfied with what the appellate court has done, you have a right to ask the Supreme Court to listen to your case, but they don't have to grant you a hearing. What is called is a writ of certiorari. And it's basically a request, will you please listen to the case? They do not grant very many.
No, they don't. And so explain to the folks the review process, the standard of review at the appellate court over the trial court. There's great deference, isn't there?
Well, it depends on what the issue is. With regard to legal issues, it's a straight up, was the legal issue handled properly or not? With regard to factual issues, there's tremendous deference that's required to be given to the district court judge. Why is that? Well, because he's the one that's been able to sit and watch the witness, visually see the body language, listen to the intonation.
On the front lines.
On the front line, determine whether he believes that is a candid witness or not. The appellate court is just reading a transcript. They are not listening to tapes, they're not watching a video, they're just reading a cold transcript. And many times what you read on a cold transcript
not the same as being there. Judge, thank you so much for being on the show. We appreciate it. This is Locke Meredith with Legal Lines and Judge Tim Kelley. Thank you for being with us today.